evening, everyone, and thank you so much for being here tonight. My name is Shakira Sanders. I am an associate professor here at the University of Idaho College of Law. I teach courses related to government structure and individual rights and liberties under the United States Constitution, including criminal procedure and advanced criminal procedure. I'd like to introduce our panelists tonight on this really, what I am very sure will be a very informative, enlightening discussion on state and federal trends on criminal justice reform. First, to my right, which I think is your left. Did I get that right? I'm really bad with the rights and the lefts.
I don't go left.
Congressman Raul Labrador, a three-term member of the U.S. House of Representatives. Representative Labrador represents the 1st Congressional District, which stretches from Nevada to Canada and western Idaho. He's a graduate of BYU undergrad and the University of Washington School of Law School. He clerked as a federal court in Boise before opening his own practice that included immigration and criminal defense, which would explain your interest in this subject. He served 2 terms in the Idaho House of Representatives before his election to Congress in 2010. Labrador serves on the Natural Resources and Judiciary Committees, where he is a leader on immigration and criminal justice reform. Last year, in 2015, he helped found the House Freedom Caucus, which is a group of reform-minded conservatives. To my far left is Kathy Grasmeyer, who is the public policy strategist for the ACLU of Idaho. Kathy joined that organization in 2010, and she lobbies during the legislative session and oversees a statewide policy agenda for the ACLU. Before her work there, she was an employee at the Idaho Community Action Network, where she helped organize Idahoans to enforce their right to vote. She is a graduate of the University of Oregon, where she received a bachelor's arts degree in Spanish and international studies with a focus on diplomacy and law, which would explain her ability to bring all of these diverse groups of people together. And finally, to my near left is Wayne Hoffman, who is the president of Idaho Freedom Foundation. He has run this organization since its launch in January 2009. He is one of Idaho's leading experts on public policy, the Idaho legislature, and the practice of journalism. He spent 25 years writing about government and politicians and has won numerous awards for his investigative and political journalism. He previously served as a special assistant to the director of the State Department of Agriculture and has successfully managed the communication efforts of several political campaigns. Join me in welcoming our panelists. So we're going to start tonight with some opening remarks from the congressman, and then we'll get perspectives from the ACLU and the Idaho Freedom Foundation.
Thank you very much. I actually love this room. I don't know how many of you know that this was where we had this, the legislature for 2 years. I was a freshman state legislator, and I was in my 2nd year. And our Speaker of the House decided that he wanted to keep the younger members of the House away from the older members of the House. And he put us up there on the rafters. And it was probably the worst mistake he ever made, because he had no control over us, because he couldn't see what we were doing. And we all had these chairs that would recline, and we would say something or create some havoc, and then we would recline all at the same time, and he had no idea who was doing it. So I think they learned their lesson, that they needed to keep an eye on the younger members of the House. But this is where I learned how to be a legislator, and I have a great deal of affinity for this building. So I was super excited when the law school decided that they were going to turn this into a law school building. I want to thank the ACLU, the Idaho Freedom Foundation, and the University of Idaho School of Law for hosting this event on criminal justice reform and for inviting me here to speak. Criminal justice reform is an issue, I think, of great importance to me, and I believe that it should be of concern to every single American. This is an area of policy where I believe we will see some of the greatest reforms in a generation, and I'm thrilled to see momentum for this issue, not only at the federal level, but also at the state level. We actually have several state legislators here today. I don't know where they went, but I think they're interested in the issue, and I think you're going to start seeing some bills also being floated in the state legislature. Last year, I believe that our bloated prison system is not benefiting taxpayers, it's not benefiting society, and it's not benefiting the inmates. Instead, we have filled our prisons with nonviolent, youthful offenders who become, in my opinion, lifetime criminals. They go to prison and they learn how to be a better class of criminals. And I don't think that's what our society should be doing. Judges who know the facts are barred from employing alternatives for defendants who may deserve a second chance. This may qualify as tough justice, but it's not smart justice. On top of hardening first-time offenders, mandatory sentences damage their families and they damage our communities. Momentum has been steadily building for reform. This Congress alone, I have met with President Obama twice. Yes, I have. Twice met with President Obama, believe it or not, to discuss this important issue. And I don't know if you remember in his State of the Union, this was the first issue that he discussed when he was speaking to us. It was the only issue I agreed with him on, not just Last year, I reintroduced H.R. 920, the Smarter Sentencing Act, with Representative Bobby Scott, who's a Democrat from Virginia. The Smarter Sentencing Act would allow judges discretion in nonviolent drug cases, ensuring limited resources are focused on the most serious offenders in our society. In the House Judiciary Committee, we're working right now through a series of bills that address our criminal justice system. In November, our committee advanced the Sentencing Reform Act, which incorporates many of the changes that were introduced in my Smarter Sentencing Act. The reforms would reduce certain mandatory minimums for drug offenses, reduce the 3-strike mandatory life sentence to 25 years, and it broadens the existing safety valve for low-level drug offenders. We also advanced the Second Chance Reauthorization Act. That bill authorizes funding for public and private entities to evaluate and improve academic and vocational education for offenders in prison, jails, and juvenile facilities. And just last week, just before I came back to Boise, we passed a bill implementing a post-sentencing risk assessment system so we could identify an inmate's risk of recidivism. The bill also establishes incentives for inmates to participate in correctional programs aimed at lowering our recidivism rates. I co-sponsor each one of these bills, which moved through the committee. House Speaker Paul Ryan has expressed his support and has promised me to bring a reform package to the floor for a vote this year. The Senate Judiciary Committee has also advanced a criminal justice package that includes many of the same reforms that we have advanced in the House. As you know, the House passes something, the Senate will pass something else, and then we'll go to committee to conference, and hopefully we will have the final bill come out. Now, the reality, before you start thinking that Congress is going to pass all these bills, these needed reforms still face an uphill battle. What we have in Washington, D.C., it's actually not a partisan divide on this issue, it's a generational divide on this issue. Many of the older, more seasoned legislators are used to what was happening in the 60s and the 70s. That's the era where they grew up, where they started forming their policies. And when we had this tough on crime legislation in many of the cities, states, and at the federal level, and it's some of the younger legislators that are coming in and realizing that we need to make a change to our crowded prisons. But criticism has come out in both the House and the Senate from fellow Republicans, and it's really pending. We don't know exactly what's going to happen, but I will continue to fight for these reforms. I think you know the statistics, but I'm just going to say a few of them quickly. Though only we have 5% of the world's population lives in the United States, the U.S. is home to 25% of the world's prison population. We have 500% more inmates in federal custody today than we did 30%. And as a fiscal conservative, this is the number that scares me the most. Spending on federal incarceration has increased by more than 1,100%, with each prisoner costing the taxpayers approximately $31,000 per year. We've forgotten the purpose of our legal system, in my opinion, the purpose of sentencing and the purpose of due process. The aim is not to coerce folks into pleading guilty to avoid harsh mandatory sentences, which happens in the federal system all the time. The purpose should be justice. After decades of failed tough on crime policies, a room of people like this leads me to believe that we're moving into a new era. When a bill like my Smarter Sentencing Act is supported by not just the Center for American Progress and the ACLU on the left, but also by Americans for Tax Reform and Idaho Freedom Foundation on the right, I think both sides of the aisle are realizing that we can't incarcerate our nation out of an inner city war on drugs or any other federal disputes. I'm honored to be in the middle of this fight that is, I think, at the core of protecting our liberties. The criminal justice system was never supposed to make it easy to take away someone's liberty. And I think if you're a conservative in particular, you need to understand that. I stand up not just for the Second Amendment or just for the First Amendment, but I will stand up for the Third and the Fourth and the Fifth and the Sixth. It's the entire Constitution that I went back to Washington to defend. Thank you very much.
Well, as somebody who teaches the Fourth, the Fifth, the Sixth, and the Eighth Amendments, that's really good news to my ears. Kathy?
Great, thank you, Shakira. If you all don't mind, I'm going to stay sitting. It's much more comfortable if you all are okay with that and you can hear me. My name is Kathy Grismeyer. I'm the public policy strategist with the ACLU of Idaho, and I first off just want to thank Shakira for helping organize this panel, and for my fellow panelists here, Representative Raul Labrador and Wayne from the Freedom Foundation. I think what we have here in the room tonight is a really exciting opportunity to celebrate maybe unusual allies coming together on an issue of such critical national and state importance here. And criminal justice reform has been something that the ACLU has been monitoring and advocating for many years now, and it's really starting to pick up steam both at the federal and national level, and I think in large part due to an opportunity for folks on the right or folks on the left, conservatives, progressives, however you want to deem it, coming together and realizing that our system is broken and it's not truly providing justice to the folks who get caught up in the system. The ACLU's work on criminal justice reform expands a pretty wide breadth of issues, most notably right now, at least here in the state of Idaho, public defense reform, which has been a large priority for the organization since in 2010, the National Legal Aid and Defenders Association came out and studied public defense delivery systems in the state and deemed that none of Idaho's counties were providing constitutionally adequate public defense. Subsequently, we ended up filing a lawsuit this past summer, and now we actually have strong, comprehensive public defense reform that was just introduced yesterday in the House Judiciary and Rules Committee, which we're very much looking forward to its progress at the legislature. I think what Representative Labrador said earlier about this generational divide that's been happening here with criminal justice reform, a lot of it is being sparked not only by the sort of ballooning corrections and criminal justice costs that we're facing, and especially in these hard economic times, it's about figuring out how do we put in efforts that allow for cost savings but also maintain a high level of public safety. And looking at our criminal justice system is a good opportunity to realize that we prioritize folks who need to be in the system and folks who there are better alternatives for them to get treatment out in the community. That's where they should be, and we should instead be prioritizing prison space for folks who really do need to be there. Some of the things that we'll probably get into later during this discussion, we'll be talking about Justice Reinvestment Initiative, which was brought here in Idaho in 2014 and looked at doing just that. how do we save Idaho taxpayer dollars from building a new prison, better prioritizing our prison space, looking at how do we reduce recidivism rates and better track what's working and what's not working. And of course, there's always opportunities for more. I think last year there was a lot of great work on some misdemeanor reclassification, taking down some misdemeanors to infractions, limiting the number of folks who would get more officially caught up in the criminal justice system, and that's continuing again this year. And also from a corrections perspective, I'd like to acknowledge we have Director Kemp from the Department of Corrections who's here tonight, along with several of his leadership staff here, who have been doing great work, partnering with the ACLU and really taking on the initiative to better reform our prison system, which does in turn help folks who do come out of our prison system reintegrate back into our society. We want to make sure that they have every tool and opportunity to successfully reintegrate back into work, employment, providing for their families, paying legal fees, and so on and so forth. And so we're very excited for tonight's panel. We're looking forward to the conversation and continuing to partner with the great representative and the Freedom Foundation in advocating for these reforms, not only at the national level, but definitely here in Idaho. Thanks.
And I know there are some people who are still coming in and looking in, and I do want to remind everyone that we do have overflow space. This is being broadcast across the hall, or you could just get a chair and find a place to put it in here. Wayne?
Thank you. Will you guys indulge me for a little bit? I want to tell a story. Is that all right? So, as you heard, I started out in journalism. Back as a young guy, in fact, our high school in Arkansas had a radio station, and that's where I started doing journalism. And as a young man, one of my first roles as a reporter was covering criminal justice. And I mean, I just loved this stuff. I had a police scanner, my own little police scanner next to my bed. It was horrifying. I never went on any dates. I always went to crime scenes and car crashes and things like that. And I truly enjoyed the criminal justice system and all the things that entails until about 1992. I may have the year slightly wrong. In 1992, and this is again in eastern Arkansas, there were these three little boys. They're 8 years old that were murdered. Some of you have HBO, probably seen a movie on this. These three boys were brutally murdered, and these teenagers were charged with the crime. They were at the time 16, 17, and 18. And I remember distinctly that those defendants were provided a public defender, each one of them. Untrained, ill-equipped, horribly outgunned, horribly outmanned. And because the community was so interested in bringing justice to these youngsters who had been murdered, there was a race to justice. And all three of those young men were incarcerated. Some 20 years later, the state of Arkansas released those three people because they found that there were obviously issues with the trial, issues with the testimony, issues with the evidence, and they pleaded guilty in an effort to leave prison. And all three of them are free today. That trial stuck with me in a way that I can't begin to describe. It said, as a youngster, that the criminal justice system has failings. And every day I see those failings represented. I have seen those throughout my career in journalism. In the 2000s, I worked for the Idaho Press Tribune and then the Idaho Statesman. And at the Idaho Statesman, I covered the correction system, and no one cared. People in the correction system cared, their families cared, but the people, generally speaking, didn't want to see news stories about how screwed up the correction system was. Where's Dan Popke? I don't know where Dan went. Oh, there's Dan. Dan may attest to this, and he may deny it. I don't know. I remember going to my editor and saying, here's a great story about a problem with the correction system, and the editor saying, who cares about that? And it might be things such as there's a problem with a law and it makes it easier for people to be incarcerated, or we have hundreds of people who are outside of Idaho. They have to be shipped off to a prison somewhere else because there's no room in the state prison system. It's amazing to me how, after all these years, the 10 years I've been away from the statesman, that now we can have an honest and open discussion about what's wrong with our criminal justice system, and people actually are paying attention and they care. They're saying, why are we locking people up for stupid things? Why are we spending all this time and money and energy in throwing away the key on people who could be productive, active members of society? So it's really cool, and that's why I'm very excited about tonight's event, and I'm looking forward to the conversation about what we can do to improve not only the congressional system, no, we can't fix that tonight, the correctional system, both federally and in the state of Idaho. Thank you.
And I want to say we can have this conversation tonight because people like you and all the people in this room continue to care. You didn't stop caring, and I think that's really important. So we have a series of discussion questions that I thought would help get our conversation going with our panel, and we'll do that for a little bit, and then we want to really open the floor up to questions and hear what questions you have on this topic. So my first question is we heard a little bit about this, but what are some of the barriers, other than this generational divide? What are some of the barriers to criminal justice reform at both the state and federal levels? Congressman?
Well, at the federal level, the biggest one is that generational divide. You have members of Congress who were there and made their careers by being tough on crime. And I'm not advocating for not being tough on crime. I'm a very conservative member of Congress. I want crime to be punished, but I think I want us to have a smart way of punishing people and to really look at the individual and how the system will affect each individual. So that's one of the things. The other thing is a lot of hardworking prosecutors use the mandatory sentencing guidelines as a way to force people to plead guilty. You know this, and I was a criminal defense lawyer, and I worked in many cases where it was to the benefit of the state or the benefit of the U.S. government to have a mandatory sentence, because the choices were you were either going to plead guilty or you're going to go to prison for 100 years. And when those are the two stark choices that you have, when there's all these mandatory sentences, it is very difficult to say, well, I think I have a defense and I can go to court and work on that defense. But if we lose, you need to understand that you have 5 different crimes that you're being charged with, and you're going to go to prison for 100 years. So that inures to the benefit of the prosecutor, which seems to be okay with some people. To me, it is not. The purpose of the criminal justice system should never be to simplify the work of the state to find somebody guilty. That's actually the most precious thing that we have in the Constitution, is our right to liberty and our right to our property and our right to all the things that we have. And when we make it easier for the state to take away somebody's liberty, I think we're making society weaker. But at the same time, we want those prosecutors to have the ability to put in prison those bad guys and bad women that are out there harming our society. And it's this great balance that we have that makes it difficult.
Thank you. And I too spent some time as a criminal defense attorney, and I understand exactly what you're talking about when it comes to the choices that your clients face once charges are brought. Kathy?
Sure. I mean, I definitely agree that there needs to be more of an attitude shift. There's definitely been decades-long mindset of being tough on crime, going after drug kingpins, but really we're seeing that smaller folks who are just have, simple possession are being swept up, and then it's disproportionately targeting communities of color and low-income community members that are filling our prison system here. But speaking to Representative Labrador's piece about it needing to be difficult for the state to take someone's liberties away, I think that's why this public defense reform issue is so important, because that is your first line of defense in preventing or at least defending your constitutional right to a jury trial, to make sure that you understand how the legal process is proceeding, and without an adequate system here in the state, and one that we would argue is unconstitutional, I think it's very possible that we have innocent folks sitting in our prisons and jails today who shouldn't be there and should be out in our communities working alongside of us, their children going to soccer games with our kids, things of that nature. And so it's so important that we protect our Sixth Amendment right to counsel and make sure that we do have a strong line of defense that's there as the prosecutors and law enforcement mount their case against you, and then you have one public defender who might be overworked, they're not getting paid the same as prosecutors, they don't have the same access to investigative resources as prosecutors do. Really, the cards are stacked against a lot of folks here in this state, and so ensuring that a constitutional system of public defense is set here does ensure that the right checks and balances are in place so that it's not difficult for the state to steamroll somebody and incarcerate them for when they probably don't need to be there in the first place.
I think there's a big political problem, quite candidly. And I'll go back and kind of take a look at where we've been in the state of Idaho. For years, there have been folks who have been wanting to change the sentencing laws of the state, and they ran into one big brick wall. And his name was Denton Darrington. I would be honest, Senator Darrington, nice guy, friend of mine, I like him. Senator Darrington was the chairman of the Senate Judiciary Committee, and Senator Darrington refused to hear any bill that would reduce sentencing or that would allow sentencing reforms. And part of that goes back to the mindset that people have that you have to have a tough on crime environment. And I think there's another part that's really very important to remember, that a lot of politicians are really afraid that if they reduce a sentence or change a law, that a bad guy is going to get out and hurt somebody, and then that person's going to become a big news story for them. That they're going to be criticized because of the action they took as lawmakers. I think the good news is that people are starting to recognize that we've swung the pendulum so far that we're locking up people unnecessarily. And going back to what Congressman Labrador said, you have law enforcement and prosecutors who pile on charges. If you're a young person, let's say you're 18 or 19 years old, and you're arrested for a crime, and they charge you, they have a whole laundry list of things that you could possibly be charged with as sort of leverage against you. If you don't plead down, we're going to charge you with all this. That doesn't just happen in the federal criminal system, it happens in the state of Idaho too. We have folks who, there's a law in Idaho called frequenting. So, and the way the frequenting law works is if you're in a place where you know drugs are being used, guilty of frequenting. So how many of you have been to a college dorm? Okay. Or a music concert. So, I mean, you're guilty of frequenting because you knew drugs are being used. So police will raid a house, there'll be, 10, 19, 20, 21-year-olds there, and everyone's charged even if only one person's using drugs. That's a problem. So we have to start highlighting these stories for people so that we can break down this wall and explain to folks, no, we're not trying to get people to be soft on crime. We just don't want people to be so tough on crime that you're locking away good people who didn't commit any crime at all.
Thank you.
And just real quick on the political angle, you realize that every word I'm saying tonight is going to be used against me. That's the point. And that's why people don't stand up and don't stand up for what's right. Because I know that I'm taking a risk by being here. In my next campaign, if somebody decides that they want to take me on, they're going to use every word. Somebody's probably taping in here right now and making, is it you? Or no. It's probably taping right now, making sure that they have this for any political, fight that they might have in the future. I don't care about that, but it's very difficult to do those things because you know that your words are going to be misused. In fact, in my first campaign for Congress, I don't know how many of you remember this, my Democratic opponent used the fact that I was an immigration lawyer and had defended people with criminal backgrounds against me. Not my Republican opponent, my Democratic opponent spent $2.5 million attacking me for the things that I did in my practice. So that's why people don't stand up, because it is difficult. And I already know what the ad's going to look like, and you're going to star in it. So no.
So what does long-term success with criminal justice reform look like? And one of the reasons why I asked this question in particular is that a lot of the conversation about the need is based on fiscal. Everyone's tightening their belt, budgets are tight, and so we want to save some money. But what happens when we go back to being more flush, when we're not as concerned fiscally? Are we going to go back to the same behavior that sort of caused us to have this rethinking? So what is our long-term goal here? What is our models for success look like? Wayne, I'm going to start with you.
I'll describe it for you. The other day, gosh, this is terrible. About a year ago, I got called again to jury duty. I get called a lot. I never get to serve, but I'm always called. And I'm sitting there, and the defendant is on trial for some kind of a minor drug offense. Okay? There are about 100 of my fellow Canyon County residents, prospective jurors sitting in the room. Okay? They're all taking the day off of work. They're not being productive. They're away from their families. They're away from their businesses. You get the idea. The defendant has a public defender who is unprepared. You can tell this person's obviously been dealing with a lot of cases and not having any time to really prepare for this particular one. And there are count them, two prosecutors working on this minor drug case, as well as 2 bailiffs and a judge and all the other things that go with doing criminal justice in the state of Idaho. I want to see that go away. I'm not saying I want the criminal justice system to go. I don't want people to be on trial for dumb stuff, where people are taking time away from their busy days and their lives and their kids and their families and their day jobs to go sit in a courtroom for some petty crime. That's what criminal justice reform should be. It's where we say we're only going to prosecute the folks who really committed a crime against society, truly. And if they didn't, then we're going to leave people alone. I think there are some really good efforts right now to do that. There are some legislators over across the way that are trying to get felonies reduced to misdemeanors and misdemeanors reduced to infractions. The other thing is, I don't want to walk in a courtroom where there's a public defender who has no idea what's going on, who've just been handed a file and they have to quickly sift through there and figure out how to do their jury selection with just a little bit of information that they have. If we can fix those things, we would have a much better criminal justice system in our state.
So I want to tell you a story, and I think obviously the fiscal issue is important, but we cannot do this just for the fiscal issue. In fact, if the only cost to society is the fiscal issue, it might be worth it to pay a little bit more to keep people in jail, if that's the only issue that we have. But there's a societal and an individual cost, and a cost to people that are going through the justice system. I want to tell you about my father-in-law. My father-in-law was the first lawyer justice of the peace in the state of Idaho. His chambers were just down the street over here, just about a block away from here. And at the time, he had the opportunity to have a lot of creative sentencing. And he told me the story about this young man who came in and he kept getting in trouble. They were all minor petty offenses that he was getting in trouble with. And one day he just kind of had it with him, and he said, "You're going to come to this address on this day, and I'm going to have you work for 3 days." So he owned a farm, and he took him to the farm to work for 3 days. Now think about this. What would happen to a judge that did that? First, he would lose his robe, because they would think that he's just doing it to benefit himself. He was having this person come to his farm to work. He didn't need the work. He has 11 children. The 11 kids can do the work at the farm. He was trying to teach this young man something about hard work, about the potential that he had. And he tells a story that many years later, this young man came to him at a grocery store and said, Judge Johnson, you don't remember me. And then he relays the story of who he was. I said, that one thing changed my life, that somebody cared enough to not just throw me in jail, but to actually teach me how to work and teach me a lesson. That's what the criminal justice system should be about. And I know that you're trying to make it that, and I really applaud the work that you're trying to do in there, because it is important that we realize that there's real people that are being affected, not just the victims, and the victims, their suffering is innumerable and insurmountable in some cases, but we have people that are going into the system, and like I said earlier, they're actually coming out as a worse kind of criminal instead of actually learning something where they're becoming better citizens that is better for our society.
And I would say to that, one of the interesting pieces to this is what the DOJ is trying to do with its new Smart Crimes initiatives, realizing that part of what needs to happen is resources need to be put back into communities, not just for victims, but the families of the offenders, because the trickle-down effect of having someone in your family who's incarcerated is quite great. Kathy?
Well, gosh, what does the perfect criminal justice system look like? We could be here a really long time.
Maybe not perfect.
With the ACLU describing what it would like, but I think Idaho deserves some credit in that we've started the conversation addressing our over-incarceration problems. Idaho has a real, I would say, addiction to incarcerating folks and locking people away who don't necessarily need to be there, and we could be better utilizing our prison space, which at sometimes we are coming up close to maximums, running out of beds, which is why we had some folks housed outside of the state for a chunk of time who are thankfully coming back to Idaho. Thank you, Director Kemp. And so we've started looking at, with justice reinvestment, how do we prioritize prison space and how do we prioritize folks to be released out on parole or probation for low-level drug offenses or non-violent offenses, keeping prison space for folks who really do need to be there. I think before we end up having to divert folks out of the prison system, out of incarceration, we should be looking at why we're sending folks to prison in the first place. That's how we can really stop this prison bloat. And federal sentencing reform legislation like Congressman Labrador sponsoring, or even some of this misdemeanor reclassification that's happening in Idaho, start addressing those issues. But we need to go further and really looking through our criminal codes and better identifying, does this really need to be a crime? Does this sentence fit the nature of the crime? Is this an appropriate punishment for folks? Because once you go to prison or jail, you don't just serve, that should be your consequence. You oftentimes lose your job, you lose maybe sometimes your familial relationships, but then you're supposed to get out and it's all supposed to go back to normal, but that's not what a lot of folks are facing. They are discriminated against because they have a criminal history. They can be denied employment, they can be denied access to housing, and those are two really crucial components to getting folks successfully reintegrated into our society. If they don't have a safe place to go home to at night to house themselves and their family members, or to be able to earn employment to pay oftentimes for their parole or probation or ongoing legal fees or whatnot, they're really struggling, and then we wonder why we have such a high recidivism rate in this state. So really addressing why folks are going to prison in the first place, and then offering what I would argue expanded community resources for folks who are leaving the criminal justice system and needing some transitional assistance in better acclimating to life outside of our prison walls. That can really help address some of the ongoing problems we see here in Idaho and sort of move us down the rosy path towards our perfect criminal justice system, if there is one. We're still working on it.
So I've got one more question, and then we'll open it up to our audience, and that includes you in Moscow, which if you have any questions, please feel free to email me at srsanders@uidaho.edu. Again, that's srsanders@uidaho.edu. So switch gears a little bit here. Are there any particular reforms that you are thinking about with regards to juveniles versus adults? Kathy, I think we'll start with you this time.
Sure. So there is actually, I was looking through the questions and I was thinking, oh gosh, juvenile reform, what's going on in that area? And there is a piece of legislation that's making its way through the House right now, and I have it, I thought I wrote it down on my notes, but I don't. But it's a House bill that was introduced last week by Representative Luker. in the House Judiciary and Rules Committee that would turn what's currently a misdemeanor for minor in possession, minor in consumption, down to an infraction. So it removes the criminal penalty for that and makes it a civil offense, so just like a speeding ticket. It does have in provisions there as well for folks to, it would provide it to be a status offense for individuals who are 18 and under, which does provide an additional layer of protection for those juveniles to make sure that they have appropriate representation in our criminal justice system under the Juvenile Corrections Act, which is a good piece. I know, having grown up here and been in high school once, not that I was ever had an MIP or minor in consumption, but it's something that is happening. Folks are learning what's out in the world and experimenting with alcohol, and so this is a great way for them to divert getting a criminal conviction at an early age, them paying the fee, and then moving on with their lives so it doesn't impact them or follow them around as they look at graduating from high school or moving on to college. So I think that's an exciting piece of criminal justice reform that will be coming out impacting juveniles in this state.
I'm going to just dovetail on what Kathy said, because I do think that legislation is very important. We've been looking for that for a couple of years. So I'll just tell a quick story. I know a girl who she was at a party, 15 years old, had one of those red Solo cups with beer in it. She's holding it. She says she's not drinking. We'll just stipulate it and say maybe she was drinking. I don't know. Anyway, she's charged with minor in consumption. 3 years later, she's in the workforce. And she's working at a call center making $9 an hour. Another call center calls her up and says, hey, you can come work for us. We'll pay you $11 an hour, but we need you today. So she says, all right. So she quits her job at the call center, goes over to this other call center where they're going to pay her $11 an hour. They're showing her around, literally showing her around the facility, when somebody from HR shows up and says, oh, wait a minute. Sorry, we've just looked at your record. You can't work here. So now she's unemployed. That's an injustice on top of an injustice. This bill that Representative Luker's put in is very, very important. It'll stop stuff like that from happening to people who, as youngsters, make dumb mistakes. I mean, name a youngster who doesn't do something stupid. Trust me, I've got an 18-year-old and a 15-year-old all the time. So those types of things, and getting rid of those laws that make it easier for law enforcement to charge young people with a crime in an effort to leverage some other charge against some other people, like the frequenting charge that I mentioned earlier, and there are plenty of others like that. We have got to stop taking adolescent behavior and turning them into criminal offenses that ruin their lives forever. And I think if we get nothing else out of this event tonight, I hope you'll, if you have a chance to grab a legislator on the way out the door, reinforce that with them, because everything the legislature does to criminalize behavior has consequences that have a bearing on people's lives forever. Just one more thing, and then I'll let it go. Right now in the state of Idaho, if you go into a store and you shoplift, you could be charged with burglary. Not petty theft, but burglary. And I just went through this with another one of my daughter's friends who ended up in that situation where she was in Walmart and she decided she wanted those eyelashes that you put on, right? I forget I don't know how much those cost, but because she was in there with the intent to steal, and law enforcement asked her, did you go to the Walmart in order to steal the eyelashes? She says, yes. Burglary, which is a whole other level of crime than just petty theft. So those kinds of things need to absolutely positively be addressed by our legislators.
Well, there's a couple of bills that are going through the House. I co-sponsor one, which is the Second Chance Reauthorization Act, which includes funding for programs that include mentoring for juveniles. There's also a little bit of discussion about regulations governing juvenile detention, how we're going to treat juveniles in prison. So there's a few little things that we're doing, but I think some of the issues that have been addressed here are important as well.
And just as a point of information for our audience, some of the court's most interesting cases on criminal procedure lately and criminal sentencing in particular have been with regards to juveniles. And this is in the past 10 years, the court has said no death penalty for juveniles. They also expanded that to include no life without parole for juveniles. In this current term, the court decided that prohibition on life without parole applies retroactively in state and federal court, which means any person who's currently incarcerated, who's a juvenile, who has been sentenced to life without parole, is entitled to at least apply for parole and have some type of determination on their eligibility. So I think that that's, from a judicial standpoint, is pretty exciting. Recently, President Obama has signaled that he will end solitary confinement for juveniles. And he's going to revise it when its use for adults. So I think I think even though it's slow, there is some movement beyond just the legislature that includes both executive and judicial acts.
And just to be clear on what President Obama is doing is he's not necessarily ending it yet. They're actually going through a study of the purposes of solitary confinement, the reasoning, and all those different things, because there are some good reasons to have solitary confinement. A lot of young people are actually at risk of being offended, violated in prison, and sometimes so if you just go ahead and say there is no isolation of an inmate, what's going to end up, you may actually be putting people into dangerous situations. So I think they're investigating that right now, is my understanding.
Thank you, and I want to remind our Moscow attendees that you can email me at srsanders@uidaho.edu. Our first question actually tonight I will take, I just got an email from someone in Moscow, and the question is, in your opinion, why do you think prosecutors do not play a larger role in the effort to reform the criminal justice system, both prosecutors as individuals and as an organization? This look on your face indicates that you're gonna go first. What is the role of the prosecutor in this conversation?
Probably somebody else should go first, just because I might get in trouble again, and the night is still young. It's interesting, the prosecutors, people think of prosecutors and they think, oh, my local prosecutor, the person who shows up to go to court, or maybe they also serve a dual role in that they represent the county commissioners as their legal attorney, but they do more than that. The prosecutors are a really, really big lobbying force at the legislature, and one of the reasons why this minor in consumption bill didn't advance a couple years ago is because there was some objection to it. And who objected the loudest? Anyone? Prosecutors. So yes, they like having these tools in the toolkit. They like having the ability to leverage these really stiff sentences against potential criminal defendants in order to achieve the result that they want. So yeah, you just need to be aware that the prosecutors are a tremendously powerful lobbying force. They show up at the legislature, and when there's a bill on sentencing reform, you can guarantee they will weigh in. And sometimes in a way that those of us who are invested in criminal justice reform don't like.
I would echo what Wayne has to say. I mean, they are a very strong presence down at the State House, one that's well respected and listened to by legislators as well. So they definitely have their ear when talking about some of these issues. And I think maybe part of the reason why, beyond just this tool, it's a tool often for them to maybe manipulate's not the right word, but to advance larger sentencing or gain really large convictions for them. But it's also an attitude shift that I don't think has quite made it down to the prosecutors. I think a lot of this conversation around criminal justice reform and being smart on crime and choosing when to appropriately seek certain sentences and what those sentences might be, that's not something that I've seen here personally in my experience at the State House and with the lobbying, with the prosecution lobbying groups that they're really considering. And so I think I hope that they're not one of the last groups to get on board with this, because it really would be great to have prosecutors on board advocating for smart on crime reforms that we're looking for. But we'll continue moving forward and doing the work that we do. I will note last year during the misdemeanor reclassifications that came through, I don't remember them being there to oppose the legislation, but we were also talking very small misdemeanor reclassification. I think if we got into larger like drug sentencing or mandatory minimums, we'd really see a very strong push from prosecutors coming out and opposing this. So I think we can start taking some small victories, but as we really start getting into the crimes and sentences that really do have a large impact on our criminal justice system, we'll definitely see them rise up in opposition. I hope they can be our partners someday.
We also have to realize that prosecutors have a very hard job. You know, they're overworked. They have a lot of people that they have to look, a lot of cases they have to look at. So, you know, I think one of the issues that my experience with prosecutors has generally been a very positive one. I have very many friends who were prosecutors. I continue to have many friends that are prosecutors. And they are trying, for the most part, to protect society and to keep society safe. So they are going to look for whatever ways that make their job easier. And mandatory sentences and tougher crime legislation makes their job easier. That's why it's the job of a legislator to weigh the balance of all the interests that are coming before them and make the right decision for society.
Great. We have a question here.
So the way I look at it, we've covered basically the first half of what happens when somebody's sentenced. You get sentenced, you committed a crime, you're found guilty, then what happens? You go into the custody of IDOC. When are we going to start holding people like Olivia Craven responsible for her actions? Somebody who had shares in the private corporation of Idaho prison. People who are keeping people in after they finish their minimum sentence. People are sentenced to 3+2, etc. They have a minimum stay, and then they have the maximum, right? They have the indeterminate, and then the indeterminate time that follows. So they go into IDOC custody, and people like Olivia Craven, Brett Reiki, are in charge of these people. They do nothing, and they let Olivia Craven run them up in the system and push people out past their minimum sentences, oftentimes only further crowding the prison systems and backing it up to the point where we're not even talking about a prosecution level now. We're talking about the back end of it. At what point are we going to start dealing with IDOC, Governor Otter coming out and saying, you know, parole's not a right, parole's a privilege? When are we going to start changing that viewpoint and start dealing with IDOC in the future on issues like this?
Well, this is your lucky night because we have in our audience today the director of IDOC, Mr. Kevin Kemp. So I'm going to turn it over to you.
Thank you. First off, where don't you go? You got it.
It's like the Price is Right.
I said lucky night might be kind of a strong word. First off, thank you. Thank you, first off, Congressman. I have, you won't know this, you won't remember, but 20 plus years ago, I was a lowly detention enforcement officer for immigration and used to work in the courtrooms where you represented, you know, clients. And you just, even back then, one of the things I respect about you is how you treated me back then. You had no idea who I was. You always treated me with such respect, and I appreciate that very much.
Thank you.
Thank you, first off, for their passion that you just had in your question. So my name is Kevin Kemp, and as mentioned before, I'm the Director of Corrections. Olivia Craven is also the former Director of the Parole Commission. We have Sandy Jones in there in place right now. Rather than kind of talk to you about what it is we're going to do, I'll tell you what we've done. First off, many of our staff are here in the audience. Since June of 2015 to today, we have 400 less inmates in our system. I was so fortunate to be able to go in front of the Joint Finance and Appropriations Committee last Wednesday and start my presentation off by telling them that we're giving them back $1.2 million to the general fund. We're able to do that first and foremost because we have put into place immediately in the past year transparency in our system. That in my opinion, our industry, our corrections industry across the country, we suffer greatly from that. We are a closed group. And when you close yourself off like that, you close yourself off to change, close yourself off to criticism, close yourself off to a lot of different things. So one of the first things we put into play is all 105 lawmakers in Idaho have 24/7 access to any single facility, any facility at all in the state of Idaho. 2 o'clock in the morning, they literally just show up, show your legislative ID. Representative Nye's in the background, he's taken advantage of this as well. show your legislative ID, you'll get unfettered access to anywhere you want to go.
Is he trying to get out or just?
I don't know. So that's the good news. The good news is that we also have, through justice reinvestment, there are several different things legislatively that we have to provide from the Department of Corrections. One of those is what we call 150% report, and it shows how many offenders do you have going beyond their tentative or parole eligibility date. And happy to report that we're crushing that right now. We're far below where we were before. And most of those 400 inmates that I just spoke of are drug and property crime offenders that are now on parole that used to sit in a prison bed that taxpayers are paying for. So pretty good stuff. Hope that answers your question. Okay.
And I'm going to invite you to take this seat just in case there are any other questions for you.
Can I just add a little bit to that?
And I'm going to let the rest of our panelists respond to any of those statements. So Kathy and then Wayne.
Sure. I think that's a great question. It's one that the ACLU has definitely been watching, right? How do we get folks who need to be or are parole eligible out in time so that if you've gone before the parole board, you've gotten a tentative release date, how do you access programming and make sure that they're being released when they should be so that they're not staying longer than they need to at taxpayer expense? And I really do think that the Department of Corrections does deserve a nod of encouragement for the work that they're doing. When we talk about this attitude change, Director Kemp and his leadership team are really sort of practicing what they're speaking about, really getting smart on crime. I know that we may not always agree on everything at some point, but we really are appreciating and enjoying this partnership that we've found with the Department of Corrections, them really taking the initiative and addressing how do folks get access to the programming they need to be able to be eligible to be released on parole. I know the Parole Commission has been doing a lot of work under justice reinvestment and making sure that folks who are meeting their parole eligibility dates are being released and that they're prioritizing folks and having them processed appropriately. I'm sure that there are some kinks that still need to be worked out, but that process is in place there. And the director has really opened it up for an opportunity for transparency for legislators and individuals to better understand how the department is doing their work. And we welcome that transparency. It's something that the ACLU is a big advocate for. We're always advocating for openness and transparency in government, and that includes government agencies like the Department of Corrections. So I'll say good job, Director Kemp. Please keep up the good work and let us know how we can help support.
Thank you, Kathy. Yeah, I just want to be really, really brief. So if you don't know how sentencing works in Idaho, basically you have your fixed sentence and then you have your indeterminate sentence. And so your fixed sentence, let's say I'm sentenced to 5 years fixed, 10 years indeterminate. Once you pass your fixed portion and you get into your indeterminate, your release is contingent upon your having completed programming. When I wrote about this issue at the Idaho Statesman in the early 2000s, the Department of Correction didn't care. They weren't really even tracking who was in the prison system beyond their fixed time. The fact that the department actually is tracking it and cares about it and wants to do something about it. In fact, they had people who were in the wrong building to receive the programming they needed to actually get out. So you have to receive a certain drug treatment program, and you're in a prison that doesn't offer the programming you need to leave. It's going to be awfully hard to complete your sentence and be able to be released. They're actually fixing that, and that's a really cool thing. And so what I just encourage, we'll keep an eye on you, of course, to make sure you're doing a good job. But I'm glad they are, and we'll applaud you for that fine work. We really appreciate it. Thank you.
Any response? Okay. Now a question in the front, and I keep your hands up because I'm gonna try to get everyone.
So this is part comment, part question, and I'll take up less than a minute. We'll have a contest of who can be briefer. Pretty good at concision. Practice a lot. And that is, I wonder if anybody's heard of the book The New Jim Crow, which argues and demonstrates quite clearly that the drug war that we created in the wake of the civil rights movement was really just our brand new way of locking up people of color. Really excellent, well done book. Wonder if anybody's heard about that. And in the meantime, while we're all sitting on our duffs waiting for the legislature to get off their duff and do some reform, I just want to let y'all know about jury nullification, which if you don't know, is the right of the people to find a defendant not guilty, even if the law clearly says that person is guilty. And this up and do the job that our legal system ought to have done many, 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 many years ago and refuses to do. So guess what? All of y'all, I'm imagining, are registered voters. And so if you're registered voters and you're part of that, jury pool thing, and so when you show up for jury day, you can find the defendant not guilty. You can convince your other jurors to do the same, even if the law, such as in the case of drug possession, which it doesn't matter if they're your drugs or not, if you're in possession, you're guilty, and it's a felony. It's a useful tool. Jury notification. That's my comment.
All right,
Thanks very much.
I'm thinking that wasn't a question after all.
New Jim Crow. Has anybody read the New Jim Crow? What do y'all think about jury notification? I mean, there's two questions there. Many things.
Any response from our panelists?
I got a question.
Okay.
Just for the corrections. About 20 years ago, we did a study about 10,000 inmates, and about 70% of the inmates were in there because of alcohol or drugs. And then at this point, recidivism, I don't know what the current statistics are, but if you take alcohol and drugs and you take recidivism, how could your correction numbers go down?
Okay, so first I'm going to let anyone respond to this young woman's question in the front, and then we'll sort of take a U-turn back to this question. And then I know that I've indicated to a few people back here that I'll be taking their questions. So.
Well, thank you for that question. And I'll just certainly echo what others have said about this. Justice reinvestment that passed certainly focuses a lot of effort in making sure that drug and property crime offender is not sitting in a prison bed, but they are in fact on parole at fiscally at $4 a day, as opposed to with us at $57 a day. One of the ways that we do it, it's a great time to be in corrections, and one of the things that we are responsible for, it's an interesting thing. We don't control the front door, we don't control the back door. The judiciary controls who comes to us, the parole commission decides who leaves. What we control is what happens when we have them, and we don't take that lightly. One of the things that we did, and this goes back to that transparency, is in March of this past year, we asked the Council of State Government, who were here 2 years ago working on justice reinvestment, we asked this one question. Henry Atencio and I, who's my deputy director, we just called and said, hey, to this group, while you were here, did you come across anything in our system that looked concerning to you, but for whatever reason, you didn't bring it to our attention? Be it that you didn't think we would listen, or you came across a sacred cow? And their answer was yes. And they pointed to our programming. They said the programming they have in our system, it did not look like it worked. And so we asked them, because we're a justice reinvestment state, we asked them to come in, outsiders, and do a top to bottom review of all of our programming. And they did that, spent several months in our system. And they found that our programs were complex, confusing. 9 out of the 12 programs that we were using did not have sufficient enough evidence to suggest that they work. They found that our therapeutic communities were more towards shaming. There was mixed reviews. And so we didn't waste any time. We discontinued the use of all therapeutic communities across our system. We just stopped them. The evidence and research was showing they didn't work. And we're going from 12 programs, 9 out of 12 that evidence said they didn't work, and we're going to 5. And all 5 of those programs are research and evidence-based. And if you're familiar with Dr. Ed Latessa at the University of Cincinnati, he's kind of the guru of programming. These are his programs that were coming in place. And so at the end of the day, and then I'll shut up, at the end of the day, what we are going to have, and we're already implementing the University of Cincinnati substance abuse model, is we're going to have a system that is simple, that is modernized, evidence-based. And so while they're with us, we're going to be efficient. We're going to do things only that work. And so they are prepared for parole when they're parole eligible, and based off of their behavior and those types of things can dictate, if they get out, not our inefficiencies within the Department of Correction.
Which question am I responding to?
Your choice.
Some clarification. Well, to get to Siobhan's point, yes, I have read parts of The New Jim Crow. I haven't read all of it. It's a great book. But I also have a terrible problem of falling asleep when I get home from work. So I fear I'm reading it like 3 pages at a time, making very slow progress. But the book's author, Michelle Alexander, used to be an ACLU staff member working out of our California office, working on racial justice issues. And I do think that she does bring up a fair point in that our criminal justice system does lock up a large percentage of folks from communities of color. And just to share some data that I found earlier today from the Prison Policy Initiative, let's see, I just have some quick stats. And these are statistics based here in Idaho prisons. So Hispanics represent 11% of the total incarcerated population in Idaho, or excuse me, represent 11% of the total population of the state, but account for 16% of the incarcerated population in Idaho prisons. Blacks account for 1% of the state's total population, but account for 3% of our Idaho incarcerated population. And American Indians and Alaskan Natives account for 1% of Idaho's total population, but account for 3% of our incarcerated population. So even in Idaho, despite our very small numbers of ethnic minorities, are vastly overrepresented based on their state populations in our correctional facilities. And in fact, even an ACLU report in 2010 looking at disparities between arrests between black and white communities for simple marijuana possessions, blacks are 2.8 times more likely to be arrested than whites on a simple marijuana possession. And so that directly correlates back to this war on drugs that does primarily target communities of color, and we do see that reflected in the statistics that we do have in our state, in our prison population. So it is a fair assessment, one that's pretty universal across the state, and even in a state like Idaho where we don't have much diversity, still is an issue in our prison system here.
So I have not read the book, but I've talked to several people who have read it. It's been brought to my attention quite a few times. I have a little bit of a disagreement with the premise that the war on drugs started for the express purpose of putting people of color in prison.
Well,
but,
if you're right, it might change your opinion, Representative.
I doubt it.
All right, well, facts and footnotes and things.
Can I answer the question?
Please do.
But I do believe that the war on drugs has had a disproportionate effect on people, on communities of color. There's no question about it. And I think the way it's being enforced has had a disproportionate effect. And I think it's something that we need to reconsider, and we need to look at some of the things. And that's why I advocate. I actually believe drug use should be illegal. I know some people would advocate for legalizing drugs. I don't advocate for that, but I do advocate for rethinking the types of punishment that you should have for using drugs, and whether it should be a citation versus a misdemeanor versus a felony. We should always look for treatment before we start putting people in prison and in jail, and crowding his prisons with people that are nonviolent offenders, as opposed to the people that we really want to be taking care of in those prisons.
So what I'd like to do is, I think there are about 3 questions on this side of the room. I'd like to allow everyone to ask those questions. Let the panel ask them. I'll do the same thing with this side of the room, and then the same thing with that side of the room. So, go ahead. Yep.
Okay. Sorry, well, out of the first 9 amendments, I've had all of the 3rd violated against me personally. So I don't even have any faith in the system that we have here anymore. But to summarize and get to 4 points exactly that I think are being blatantly ignored. One is excessive bail. That's what exactly is being reformed so that is imposed. Having been victimized by that myself, gee, I'd sure like that addressed. The next is property theft, especially guns. That there's no default return policy. I had a firearm taken a decade ago that was turned over to the ATF for testing and now returned a decade later. The other is incompetent assistance of counsel. It's actually twofold. I've been told that if I hired an attorney and he was an idiot or didn't prepare a defense, that I can't, on appeal, use that as grounds for considering that perhaps there was issues with the trial. On the other, it had been threatened by the public defender's office with the charge of criminal trespass for instructing the public defender on how to prepare my defense. The other one is called what I call multiple choice convictions, where you're trying for one thing and then the jury's given a bubble sheet, which happened to be out in Fayette County, where I was trying for one charge, a felony charge, and then they were able to find me guilty of a misdemeanor that I wasn't even charged with. Thank you.
All right. Is there another question on this side of the room?
I had a question about grand jury reform. So at the federal level, the grand jury is required. In Idaho, it's optional. But it's kind of universally recognized that the old saying that a prosecutor can get a ham sandwich on a grand jury The legal system, commentators pretty much universally recognize that all grand juries aren't functioning the way that they were intended to, and they're kind of held hostage by the prosecutor. But I never hear about grand jury reform at either the federal or state level, and procedural safeguards that could be in place to help this group of 16 citizens who are here to not only decide if somebody should start down the road being charged with felony, but if it should even begin in the first place. So is there anything that can be done on any level to help the grand jury with its purpose?
Okay. Anybody else here on this side of the room? All right, so I'm going to sort of summarize these questions. We've got some concerns about excessive bail, property confiscation, effective assistance of counsel, the ability of the prosecutor to obtain a conviction on a lesser included charge that was not actually charged in the indictment when a jury declines to prosecute on the higher included charge, and then grand jury reform. So are there any components, any comments on any of these components?
Most of those issues were state issues, so I can't really address them, but in the grand jury reform, I haven't really thought about it, so that's something that I probably need to look into at the federal level. I just frankly haven't, I've been concentrating on other aspects of criminal justice reform, and there's so many things that we're working on, but it might be something that I may need to take a look at that.
Well, I personally have served on a grand jury before, so that was an interesting experience, but which I can talk about afterwards and won't talk about from an ACLU perspective. But at least speaking about public defense reform, I mean, this is one of our key critical criminal justice issues that the ACLU has been advocating for since 2010. And this year we're finally seeing legislation that, like I said, was just introduced yesterday. It's been a very long, slow, arduous process with many legislative interim committee meetings with panelists and experts and public defenders and prosecutors coming in and providing input. And this collective group of senators and representatives has come together and put together some legislation. And just to quickly kind of summarize what's included in the legislation, because it really is, I think, one of the largest pieces of criminal justice reform that the state has looked at in the most recent years, other than justice reinvestment. I think this is a really strong piece of reforming our system and ensuring that there are safeguards, protections for our constitutional right to adequate defense. So the legislation is sort of three components. One, it includes principles or standards. There's been some discussion about what word is appropriate or what word legislators feel most comfortable with, but standards that basically outline how public defenders should be doing their work. Things around having the process be free from judicial or political influence, allowing for greater parity between prosecutors and public defenders in pay, making sure that public defenders can meet with their clients in a private room so that they can appropriately and openly discuss tenets of an individual's trial. Then it also puts together a funding mechanism. Right now we know one of the largest problems with our public defense system is the lack of funding that counties face. And at this point, the counties are paying for a state responsibility to provide public defense. And so the counties will maintain their payment. Right now, they use their justice levy funds to finance public defense in the counties. But the state, I think Governor Otter has come forward and allocated, I think, around $5 million in his State of the State address for public defense. That will then create a pool. Counties can write to the Public Defense Commission, which will be the sort of oversight body for public defense reform in Idaho, requesting funds to help cover some additional costs they might have and ensuring that they are compliant with those standards. And then sort of the key component for us is this enforcement mechanism so that we can answer the question, if a county is not providing constitutionally adequate public defense, who is held responsible? Because there are still hundreds of thousands of Idahoans who go to court every day with a public defender who need to be assured that their right to their constitutional right to public defense is being maintained and held. And so this enforcement piece comes in and it provides opportunities for the county and the Public Defense Commission to sort of mediate a solution. And ultimately, if a county is materially negligent in providing public defense, the Public Defense Commission can come in and provide whatever sort of service is not being provided to indigent clients and could even intercept funds from the county or the Public Defense Commission to then supply that public defense service. So with the caveat of there not being enough funding, $5 million is a good start, but nowhere near adequate. We think this is a pretty good bill and definitely provides far more comprehensive legislation and direction for the state than there ever has been before, which I think will help alleviate a lot of the problems that many indigent clients face in the state. An interesting fact, 1 in 3 Idahoans could not afford a private attorney. So this is a really critical issue that affects a lot of folks across the state.
All right, so let's take this swath of the room. So we'll take the first question in the back, and then we'll take your question in the purple sweater.
Specifically for Representative Labrador. The New York Times expressed concern last week that the Sentencing Reform Act would not get through this session specifically because people were attaching amendments to it that were not necessarily germane to it and probably couldn't pass on their own. And they're worried it's going to die this year. Is that what's going to happen?
Well, good ideas always die in the Senate. So, and that's what's happening right now in the Senate. They're going through a pretty big fight on sentencing reform, and there's a lot of senators that are trying to kill it, and they're very strongly trying to kill the sentencing reform. We have a little bit more support in the House, but frankly, the stronger that they're fighting in the Senate, we're starting to get more and more opposition in the House. So it is making it more difficult. But I will have to say, I did a press conference with Sheila Jackson Lee, and she was very excited because she said this is the closest we have ever gotten in 30 years to having any kind of sentencing reform. And when you have, so we are getting closer. I think you have more and more people, especially as I indicated earlier, as you get more and younger members of Congress going into office from both parties. But there's still some pretty stiff opposition. And we have been trying to reform the criminal justice system now for 30 years, and I think we're as close as we have ever been. But we're going to continue to fight. You have Mike Lee, who's been a hero, from Utah in the Senate. You have me and others working in the House, and we're going to continue to work for it. But it is a heavy lift. It is a very heavy lift, and we're going to continue to work on it.
All right, so I'll take a question from the woman in the purple sweater here, and then I'd like to see, I think there's one question on this side, 4 questions. So let's maybe take this one in the middle, and then the back 2 questions, and then I'll get sort of this front swath.
So Congressman Labrador talked about the difficult choice. We are presumed innocent, but when you're facing a prosecutor or a charge or a series of charges, the concept of plead guilty to this lesser charge or series of charges or face the consequences of the potential of being found guilty and going to prison for a very long time. The other thing, I guess, the corollary, the idea, and maybe this is a question for the director, that one must acknowledge guilt before one is allowed out on parole. And that has always bothered me. If we're presumed innocent, have never pled guilty, or even if we've pled guilty under those circumstances, there are people who are innocent who go to prison. And then they're faced with, we're going to keep you here longer unless you admit to doing something which maybe you did, maybe you didn't do. And that has just always offended my sense of fairness. Is that a requirement these days? And if so, why and what can be done about it?
All right, let's get the question in the back here.
I'm a gang prevention intervention specialist out of California. My name is Peter Vasquez. And I was wondering if the law is still in place in Idaho where you have a gang law that sends people to federal prison. And when you send people to federal prison on a 5-year term and they come back and grow into your community, it's very dangerous because it's federal prison. None of you know about corrections. I do. I was in corrections and worked in the worst prisons in California and as well as youth court. And one of the things is like going to Yale criminal school. We send somebody with a 5-year term out of our district and out of our hands, and we don't know who's his salary. His salary could be John Gotti. Well, he's dead, but still. You get what I'm saying? They could be the biggest drug trafficker in the United States that he settled up with. And then when he comes back into little state of Idaho, this was 9 years ago, 8 years ago, if you guys remember, the administrators put in place this law. And I don't think they did their homework right. That's kind of dangerous. 8 years ago, I couldn't find heroin anywhere in Idaho. You had to go to Salt Lake, you had to go to Oregon, you had to go to Utah, wherever, you had to go somewhere out of the state. Today, you can find it downtown Boise. Every tent that I was down there had syringes except for 2 of them. And there's a lot of drug trafficking. We just saw a story the other day on an 84 when there was a turnover, kids from California dropping off their drugs or whatever in our state. But I can tell you one thing that I just wanted to know, was that going to be in place in the kind of future, stopping that? When they have a life sentence in federal prison, they don't come back to the community. But when they do come back, and I know the cases firsthand, because I work with a lot of inmates, and they confess like a canary to me. I get more information off them than law enforcement, because I've been where they're at.
Okay.
So,
first of all, I think it's very exciting that all of us are here tonight. I think that it's great that you guys are here. This is kind of for the entire panel, but especially you, Congressman. We have certain legislation that's been passed, like Amendment 782. We're trying to reduce these mandatory minimums. We're trying to get people out of prison on these nonviolent drug offenses, but yet we seem to have these stonewalls, like the Bureau of Prisons, where BOP gets their reduction, they're not let out because they all of a sudden modify their RDAP. So they're doing all their programming, but they're not being let out when a judge is telling them to. What can we as citizens do to get Bureau of Prisons to get off their butts and let people out when they're entitled to be?
All right, so I'm going to summarize these questions again, and I promise to do my best. We have some concern about the presumption of innocence, which is a constitutional right that we all enjoy, and in particular, how the guilt admission for prerequisites affects parole. We have another comment or question that talks a lot about the increased federal incarcerations for state prosecutions for gang activities, and then increased drug trafficking in Idaho. And then finally, we have a question surrounding the concern of stonewalling between federal corrections agencies. And before you begin your answers, I just want to let the folks in Moscow know I have your questions. I'll be including those with the final group.
Well, I want to address the presumption of innocence real quick. I actually did a lot of parole work when I was a criminal defense attorney. In fact, there was a period of time where I was probably at every parole hearing that they ever had in Idaho for a couple of years. And that is a difficult question because, you know, I think you should have the presumption of innocence when you're going to trial. But once you have either pled guilty or have been found guilty, the system assumes that you're guilty. They don't assume that you are innocent, or else they would be assuming that an injustice has been done. And for the parole commissioners, at least the ones here in Idaho that I have worked with, I think that that's just a mindset that you're going to have to, if you want to get out, you have to admit at some point that you committed a crime. And that was one of the things that I had to work with my parole clients, to talk about what really happened, go through the story, and sort of try to help them explain in their own words what happened. And in some cases, you do have to admit that you did something wrong, because the prison system's not going to let you out if you're claiming that you haven't done something wrong. And so that makes it very difficult. And I don't know that I have a problem with the system assuming once you're in there that you are guilty. But that's why I believe that we need to look at it from the front end. How do we keep people from going to prison who are nonviolent offenders first? And also maybe the number of felonies that we have. Maybe there's some things, we keep adding felonies to the criminal code, both at the state and the federal level. Maybe there are some actions that should not be counted as felonious. They might be wrong, they might be civil violations, or they might have, maybe misdemeanors, but maybe we need to really start reconsidering some of these actions that we're actually sending people to prison on for long periods of time. But once you have been found guilty and adjudicated guilty, I think the system has to assume.
You no longer enjoy that.
You no longer enjoy that.
Now, I did want to remind you that there was a specific question about the congressional, oh, actually that one already got answered. So any other thoughts from our series of questions?
I want to back up what Congressman Labrador said with regard to the front end. And I'm just going to give a quick example with a piece of legislation from last year. There was a bill, and I'm going to briefly and very, very inartfully describe marijuana for just a minute. There are essentially two components, if you will. THC, which makes you high, and CBD, which is extracted as an oil, which has been used to help people with seizures and other medical conditions like that. Doesn't get you high. But there have been kids with intractable epilepsy, for example, who could really use CBD oil. Last year there was a bill that said, all right, we're not going to go and arrest anybody if you have CBD oil and you're bringing it home to your kids. And that bill narrowly passed the House, narrowly passed the Senate, was vetoed by the governor. Or as I like to say, in Idaho, politicians are really against big government except for when they're for it. And this is an example of that. And what we're ultimately saying here is, if you are carrying CBD oil on you and you're bringing it home to your kid to potentially treat them with treat their condition of intractable epilepsy, the state of Idaho is willing to arrest you, prosecute you, and jail you. I think that's wrong. So the problem that we have is that we have too many laws. We have too many things that people can be arrested for, too many crimes that you can be convicted for. And if we're really ever going to get a handle on all the problems that we talked about in our prison system, we have to start with these laws that lock up people for something as simple and as innocent as trying to help a kid who has a horrible medical condition.
I think Wayne kind of eloquently stated some of the thinking or thought process that's going on here. We're so, Idaho is really trying to move forward and take the right steps in reforming its criminal justice system. And when something as simple as providing a non-addictive natural supplement to young children who have a very terrible medical condition gets so clogged up in the process with the Office of Drug Policy and prosecutors coming in and testifying against this, saying, we really, our hearts go out to your children, but this really opens the door for X, Y, Z. I mean, we're really we're reaching a bottleneck where we can't really move through, and yet these are reforms that are really necessary and get to the point of thinking, is this really an appropriate crime? Does this need to have a sentence? Do we need to be sending people to prison for that? Should we be sending mothers to prison for providing a natural supplement to their children to help treat intractable epilepsy? I would agree with Wayne in that the answer is no. The ACLU will go even farther to say that we should be legalizing medicinal marijuana. We have our neighbors to the west who are doing it. We have a lot of our neighbors here in the western states who have legalized CBD oil, Utah included, and Idaho is slowly moving behind that trend. We're really kind of lacking progress in that sense. And when we can start addressing drug sentencing, mandatory minimums, then we're really going to see a drop in the number of folks who are being sent to Idaho's prisons and jails. That's really the missing component that's not being discussed here in Idaho. And it's difficult to come out because I know it can be a hard position to take. We certainly get some feedback for that, but it takes, elected officials taking that brave step and realizing that it does have an impact on families. Sorry. We can talk in the dark.
Yeah. This is an automatic thing. It's actually happened when I've taught in this class before. So.
I mean, it has an impact on families, it has an impact on our criminal justice system. There's a significant cost saving to taxpayers. And really, it's a common sense piece of legislation and reforms that we should be taking advantage of here. And we'll keep talking and encouraging lawmakers to make that right choice. And until then, we'll keep on advocating.
Thank you. Just want to point out that Congressman and I were just talking about this, but there's people that talk about it and there's people that be about it. And I just want to go back to Peter Vasquez. and express appreciation to Peter. Peter could be doing a lot of different things with his life right now, and what he's doing, he's taking this knowledge and history that he has, and he's in this passion, he and his wife, and he's applying it to the good. One of the things that Peter and his wife do is they have an organization that works very closely with gang members who have, in many cases at a young age, tatted themselves up, big time with, their prison tats or, gang tattoos and whatnot. One of the things that Peter and his wife do is they work in this organization that helps these gang members that are coming out of our institutions get those tattoos removed from them, that allows them to be more presentable and those types of things. And, we have a lot of people out there that sometimes aren't heard, but the Peter Vasquez's of the world and his wife they're just being about it, they're just putting their passion towards really, really good things, and just want to express appreciation for him and his wife and all their efforts and moving this needle in the right direction.
All right, so let's take our last vignette of questions from this side of the room.
I have a question for the panel and for the director. The question for the panel is, while I generally agree with your previously stated assessment that most prosecutors are fine, upstanding citizens and doing their job to the best of the ability that they have. However, we've all seen in recent years prosecutorial misconduct. Is there any discussion amongst the criminal reforms for penalizing prosecutorial misconduct? That's for the panel. For the director, while I applaud your efforts, and by the way, 20 years ago I was in the legislature and I did go visit south of town. I got a surprise visit, and I got a substantially different tour than when we went on the company-sponsored tour. But apart from that, I applaud your efforts and what you've done to take 400, to have reduced the inmate population by 400. My question is, let's assume that you can do that next year and reduce the prison population by another 400. Is that not somewhat counterintuitive for a government agency to be reducing the requirement for ever-increasing employees? And how do you adjust your employee morale based on reduction in workforce?
All right.
Yeah, I was looking at the history of the Idaho bicycle stop loss recently. And what was entertaining when it got me was basically if you're on a bicycle, a stoplight works as a stop sign. If you go to a stop sign and you're on a bicycle, this is a yield. And I wasn't able to verify sources, but regardless, the point remains. The narrative I read was that it came from Idaho judicial offices, whatever. And they went and looked at Idaho law to find laws that could be reduced to reduce infractions and make overall life better. And I thought that was fantastic. And for those of us who ride around bikes all the time, it's great. I mean, traffic flows better for everybody. We're not a harm to ourselves or anyone else. It's fantastic. What kind of initiatives and drive are we seeing to what we call in software land code reduction to pull down laws that are inherently just not a proactive, not a good thing overall for what they end up making violators from, I guess I'm trying to say. Thank you.
All right. So I'm going to summarize this vignette of questions and then, we've got one more, sorry.
No one really has mentioned yet where it all starts, and that's with police. And I want to know, from my experience, it seems like police have their priorities all wrong. And twice in my life, I've had thousands of dollars of property stolen from me, and the police, I even had a surveillance video who did it, and the police wouldn't give me the time of day, they could care less. I kept having to call them over and over again, and they didn't care. Yet they detained me and my family with a 3-year-old and a 5-year-old and a 6-year-old in a public park because a 5-pound chihuahua was not on a leash for an hour and called in 8 backup police officers. And it doesn't make any sense at all that you can detain a family for a 5-pound dog not on a leash, but then don't investigate thousands of dollars of property stolen from someone. And so I want to and hide out all day with speed guns, getting people speeding. Like, I want to know what we can do to see where the police are allocating their human resources and financial resources. Because to me, it seems like it's all backwards and they just do what's easy.
Okay. So in the room, we have 4 questions, one directly for the panel and one for the director. One asking what criminal reforms can we put in place for the penalization of prosecutorial discretion? And then the question for the director was how do these reduction in prison populations ultimately affect employee morale? We had another commenter on laws affecting Idaho bikers and how do we sort of begin the process of maybe combing through our code to deal with ineffective laws. Another commenter or question was about how do we ensure the effectiveness of law enforcement and begin to address law enforcement overreach. In Moscow, we had a question asking about criminal reform to address the increase in college rapes.
College what?
College rapes and college sexual assault. And are there criminal justice reforms that we need to look at to better and more effectively address that issue? Another question had to do with how do we deal with removing the stigma placed on felons due to their felony status. And that stigma is one that stays for a lifetime. Another question asked about should we be looking to foreign models for drug retreatment and decriminalization? And then finally, how do we deal with the issue where sometimes when we streamline criminal defendants from misdemeanors to those who are only committing infractions, but then we impose upon them fines that are too high, and thus that causes other collateral consequences. That was a lot.
That's a lot. That was a lot. I'm going to address one issue. I sat on a panel that I was assigned by the Judiciary Committee chairman to sit on a panel that dealt with criminal reform for a year. And it was a bipartisan panel. We had some really good discussions about a lot of the issues that we're talking about here today. One of the things that we did pass out of the House was a bill in November that cleaned up our criminal justice system, that tried a criminal code, that sort of went through it line by line and we didn't complete the project, but it was the first step in the project to look at different kinds of laws that are in there that were either old or were unnecessary, and we got rid of a lot of just parts of the criminal code. That was one of the things that we did. The other thing that we have been working on is the issue of mens rea. There's a lot of, and anybody who's in law school understands what mens rea is. What mens rea is, do you have an intent, an evil intent for your actions? The federal criminal code is riddled with laws that have no criminal intent. They're, in fact, in strict liability criminal crimes. And we are trying to get rid of those. And there's a big movement to get rid of just about every crime that does not require an intent. And if you think about it, there's thousands and thousands of those crimes in the criminal code. And then the third thing that we're doing, and this is the fault of Congress, we have passed a lot of laws that say X and Y action is a crime, but we don't give it a sentence. So it's actually the regulatory agencies that are deciding what the sentences are going to be and the punishment is going to be in those cases. And we're also going through the code and trying to get rid of, taking that authority back, and we will decide what the sentences are, what the minimum, what the maximum sentences are. So we've engaged in this prolonged, review of our criminal code, trying to make sure that we get rid of bad laws and we actually are punishing people for crimes that they intended and not just for their actions alone, which will deal with a lot of the issues that we're discussing here.
I'll address two issues briefly. One about sort of the police accountability and transparency. One item of importance that I think is going to start, well, the conversation has already started, but I think will only intensify as technology sort of develops and advances, is the use of body-worn cameras for law enforcement. And really it's the sort of an appropriate tool, not only that allows transparency from a public perception. Law enforcement would then be required upon onset of some sort of encounter with a citizen, whether it be a traffic stop or you're being stopped on the street, that camera goes on and it allows for the public to better understand, what exactly happened during that interaction. But it's also a good tool for law enforcement as well, for them to protect themselves, for them to be able to be recording saying, I followed protocol and procedures here. But it really is a good tool for accountability for the public to better understand how use of force might be used, for us to understand what policies might need to be changed, and really does provide an opportunity for the public to be, what is the word I want to use? For the public to be able to address and understand how law enforcement is handling itself. If there are videos that are flagged of interest, excessive use of force, deadly force, and we've had some instances of that. I think in Idaho in 2015 there were 13 deaths by the hands of law enforcement, and some of them are still under investigation and not entirely conclusive. But if we were to have a body-worn police cameras, we would at least be able to better understand what was that interaction like between law enforcement and that public citizen, and better understand what went wrong in that interaction that could then be addressed. The other piece about these, what I would call collateral consequences of a criminal conviction, I think there's a lot of conversation starting to happen around how do we address the stigma that's associated with having a criminal conviction. As I said earlier, you go to prison or jail to serve a sentence. It's a punishment, and oftentimes those punishments extend beyond prison or jail, where people are denied access to housing, denied access to employment, and really they're just unable to successfully reintegrate into society. And so there's a push at the federal level called Ban the Box, which would bar certain employers from asking about an individual's criminal background, so that folks who have felonies on their records would be able to be eligible for additional employment. If you want folks who are qualified to have the right kind of jobs that also provide the right kind of financial compensation, they can afford a home, they can pay for their families, they can pay for restitution. There are a lot of things that we count on our jobs for providing, and people who are coming out of the criminal justice system have already paid their debt to society, should be able to access employment and be able to move on with their lives. And so that's something I look forward to progressing nationally, and then I'm hoping that conversation will come here to Idaho as well.
I'll be super brief because I know we're over. First of all, there are occupational licenses where it says you can't participate in that occupation if you've been convicted of a certain kind of crime. Sometimes it's just any felony. And that's an issue, and we've been trying to point that out more and more as occupational licensure laws come to the legislature. Not a fan of occupational licensure at all, but that makes occupational licensure even worse. The second thing is getting back to the question about the police and the abuse of law enforcement activities. All of this really goes back to what legislators and governors authorize law enforcement to do in the first place. If you don't give them that authorization, it's not going to be a problem, and you're not going to have law enforcement going off and doing stupid things. I know this doesn't have anything to do with criminal justice, but case in point, last year, the Idaho State Police, which we are always told is short-staffed, don't have enough people to go patrol the roads, sent two detectives to the movie theater in Meridian to sit and watch 50 Shades of Grey and be served gin and tonics so they could go and enforce the alcohol beverage laws that say that you're not allowed to watch a provocative movie and have alcohol at the same time. You can do it at your house, I guess, for now. but you can't do it at a public movie theater. So if we really want to focus our resources on things that really matter, then we have to have legislators and governors that are willing to stop passing stupid laws that treat people like little children.
And I think that is a good note. It's a good note upon which to wrap up. And I want to thank you all for coming. And I hope you enjoyed tonight's program. And I hope this is the start of a dialogue, not to end.